Hi, everyone. Welcome to another episode of the Ask Amity Show. Jennifer, I'm here with Cindy. So today the topic is, can a lien be put against a living trust? So this is a pretty common question about asset protection and whether or not living trusts would help against creditors. So a problem we often face with some of our clients is, maybe a living trust was created, and then there are certain creditors right now that are going after their assets. So are the assets protected now that they are named in the living trust? So, number one, and kind of the purpose of an actual revocable living trust is to keep the contents of a will private or to guard against the mishandling of funds intended for specific recipients upon your death or some future date. So this instrument also allows you to pass property and other assets to beneficiaries without the need for probate. So that's really the target and the objective of having a revocable living trust executed and prepared. So this usually will save time and expenses in avoiding having the hassle of going through probate. Although a lien cannot affect a living trust as an intangible entity, a lien is usually enforceable against the assets it's transferred into that trust.
So it is a common misconception that a living trust automatically protects assets from a judgment or a lien. Generally, all property transferred to a trust is still the property of the person making the declaration of trust, unless the transfer constitutes a sale. So in this video, we're talking about revocable trusts. So most people in a revocable trust will appoint themselves as the trustee to retain control of the trust assets during their lifetime. This means the trust is revocable and can be changed at the discretion of the grantor or trustee at any time. As such, the property is subject to seizure as the result of a lien if a court awards a judgment against the grantor of the trust. However, the lien only attaches to the grantor's share of trust assets in the trust. In the case of a married couple's trust, it will only attach to the grantor's share, or perhaps maybe there are assets in there that the grantor shares with siblings or parents. It'll only attach to that specific grantor's interest of that asset. So that's all we have for you today. If you want to talk more about living trust and asset protection, give us a call. We're more than happy to consult with you. We offer a free 20-minute consultation for all new clients. Again, thank you for watching and make sure to subscribe to our channel. See you next time.